My lord, I file an interlocutory applications for implementing as party respondents. Next week,
My lord, I beg to mention for an unlisted motion, my lord.
Today?
Today, my lord. This society matter, my lord.
Yes, sir. Yes, sir. Yes, sir. Okay.
Supplementary list for motion, item 7.
No, please, no. These are the additional facts.
Where is the ATS provision?
This is the corrigendum. My lord has the corrigendum at page 129. And relevant is at 130, serial number 5. Well, on facts, my submissions are twofold. One is that as per the scheme of ATS, the seller and buyer were required to initially execute an agreement as per the tender, deposit the money, and then within a window of 4 months, the RC and PESO was to be transferred. Now, the work order or the allotment letter in these cases were issued on 16/9/2025. The window of 4 months will get over on 15/1/2026. That is the 4-month window. Now, the difficulty that we faced was that during this 4-month period, there were 2 extensions granted to the seller under his earlier contract. As a result of which, the testing, physical verification could not happen, and therefore the PESO license could not be taken, to be more precise. So these extensions, the first extension was up to 31/10/2025, and the second extension went up to 31/12/2025. So effectively, my window of 4 months from LOA was reduced to 15 days. So therefore, within those 15 days, I could not practically get the PESO license. That is one. That is the first on facts. The second aspect on facts is that they gave me a final reminder on 15/1/2026 saying that please submit RC and PESO by 9 p.m. tonight. This email also says that in case the bidders are unable to obtain PESO, then only upload the RC and the tentative date on which the PESO will be received or obtained. This is something that I need to upload. I wrote an email on the association on behalf of all the petitioners, wrote an email on the same date on 15 prior to this final reminder saying that kindly grant us 15 days more. We will comply with both RC and PESO by 31st of January. Now to my email, to the association email, there is no reply. But all the members of the association before 31st get the PESO licenses as well as the RC licenses and they upload it on the website, which is accepted. Now, by 31st of January 2026, the formalities are over. But on 5/3/2026 is the show cause notice. Now, there are two things, two submissions on show cause notice. Rest on the facts is similar to the one that happened in the last week. On the show cause, there are two submissions. I completely agree, my lord. Show cause, the jurisdiction is very limited. It has to go back. The authority has to decide. The final order has to come.
Have you placed all these facts in your representation?
Yes. And show cause can be interfered at this stage only when there is lack of jurisdiction. But here, my lord, there are two aspects. The first aspect, in my respectful submission, my lord, is that the suspension which is attached with the show cause shows there is premeditation. Because at the issuance of show cause, without receipt of a reply, without calling for a reply, there is already a decision taken to suspend, which is a penal action.
Suspension is not per se penal.
But my lord, there is already a premeditation.
If you go by service jurisprudence also, suspension is not.
Service jurisprudence and commercial jurisprudence.
I know, commercial jurisprudence also. The suspension is mere suspension.
The decision to issue a show, I would have understood, my lord, if it was a show cause, saying that you show cause why you did not comply with it within 10 days or 15 days, and then they would have decided that in the meantime, the vehicles would have continued to operate. But here, at the time of issuance of a show cause, there is already a decision to suspend me interim.
Is there any provision or not
For
suspension?
No, my lord. There is no provision of suspension because the clause which provides, my lord, will see page 130. And at 131, my lord, the second last para at 131. In case bidder fails to submit the required documents with change of name, etc., within 4 months of issuance of LOI, suitable penal action shall be taken, which shall include EMD forfeiture, caution money forfeiture, termination of order of such treaties, blacklisting of such treaties. Under no circumstances will above mentioned timeline be extended. In such cases, the contracting corporation reserves the right and liberty to induct treaties as per the methodology mentioned in the tender to fulfill the shortfall arising thereof. So this punishment is contemplated after there is principles of natural justice have been complied with. After there is a show cause, there is a reply, and then they can decide. But this show cause with this order of suspension along, without a reply even being sought for or called for, is, my lords, premeditated, in my respectful submission.
Let us see the bidding document.
Bid document, my lord, starts at page 22. The concept of ATS was brought in by the Corrigendum. At page 42, if my lord says, pre-qualification.
It will be definitely in the holiday listing guidelines.
I'm sorry.
Holiday listing guidelines.
Yes,
This suspension.
I didn't get it.
I think this is this also a consequence is also debarment or holiday listing.
Holiday listing or like.
It is in the guidelines.
Yes.
This power of suspension. Yes, Mr. Sharma. Do you have the guidelines?
My lord, as of now, I do not have the guidelines handy, my lord.
Ah.
Your lordship,
In which case? In which case?
My lord, addition, creation, rhino.
That in those cases.
Those cases, my lord. Yes, my lord. 20,
CAV.
20, yes, my lord.
The rasayanik sanction.
23 guidelines.
CAV.
Today, my lord, even going by their conduct, there is a subsequent complaint which they have accepted it. It is only after over a month that they issue a show cause.
My lord, may kindly come to page 123, my lord.
Just a minute.
My-
Let me organize myself.
Yes, ma'am. Yes, ma'am.
These existing contracts
Yes.
with the proposed sellers are also with the IOC.
Yes. IOCL, all are with IOCL, and then they enter into it.
So all these facts you have brought in the Representative,
Yes.
then 23 এখন আছিল না এইখন নেকি Let us see the show cause notice.
Thus we'll find the show cause notice at page 167. May I read, man? 167. This is further to the work order number so and so dated 27/9/2025, whereby contract was awarded for induction of one number of TTs, out of which following TTs were awarded under agreement to sale. So and so number is there. Kindly note that the above mentioned TTs were considered as own TTs during evaluation of tender, which was in line with the provisions of the tender published in point number 5 of the corrigendum dated so and so. As per the conditions, the transfer of truck documents, that is registration certificate, PESO license in the name of purchaser, was supposed to be completed within 4 months of issuance of LOA. Please refer to the following clause mentioned in the said corrigendum, which is page 130. I read that part. Since you have failed to submit the required documents, that is RCPC license in name of the purchaser of the TTs within the stipulated 4 months from the date of LOA, it calls action as stipulated under above mentioned clause. Hence, your above mentioned TTs have been placed under suspension with immediate effect. You are requested to submit your reply to this show cause notice within 7 days from the date of receipt of this letter. Why further punitive action like forfeiture of EMD and caution money, including for termination of contract of these TTs, should not be initiated against you. Please note, in case you fail to respond or provide an unsatisfactory response, IOCL will be left with no other option but to terminate the contract of such ATS trucks along with other actions and get the work completed as per methodology outlined in the tender. This communication is issued without prejudice to other rights and so and so.
So 168 is your reply.
168 is my reply. Where, my lords, if I may point out, at para 3, the undersigned was issued LOI on 16/9/2025 under the tender in question. Thereafter, by an email dated 8/12/2025, your organization instructed bidders falling under ATS category to submit the necessary documents showing change of name, transfer of vehicle ownership along with PESO license within the stipulated 4 months on or before so and so. The said email further threatened non-submission or incomplete submission of documents for delay in submission of documents would attract penal consequences. Thereafter, they wrote further emails, and then, my lords, in the fifth para, thereafter, final reminder 15/1/2026 was issued informing the bidders under ATS category to submit all relevant documents latest by 900 hours. The bidders were also given an option to only submit RC along with PESO amendment application or the expected date of completion of PESO amendment. However, it is relevant to note that though the LOIs were issued on 16/9, the cutoff date under the ATS category was 16/1/2026.
All representations are of same nature?
All-
All representations are similarly.
It's
What-
from the association, there is one representation of 15/1.
Oh. Yes, Mr. Sharma.
But before my letter friend comes in, there's 2 more points. First point is,
Let them have the liberty to examine all your points.
but my lord, my only grievance is the suspension which is attached with the show cause. Because if my lord looks at the show cause once again,
Should I answer that? Should I answer that?
No,
Then that will be again
no, and the second thing,
matter of appeal.
the second,
And it will be foreclosed.
no, and second thing, my lord, please see the conduct. 15th is the cutoff date which they prescribe. I comply with it by 31st of January. Thereafter, they accept these vehicles. These vehicles are
It is
loaded.
not a matter of conduct. It is going by the abiding by the terms and
No,
conditions of the
very well, but-
contract, and for reasons beyond your control, this condition could not be complied with
complied.
in time, right? And they have acted otherwise as per the terms and conditions. But discretion lies with them. Yes, because of the situation that have arisen in the meantime, because of the extension of the
Earlier contract.
contract. So those are also within their
Within their discretion.
So that discretion is definitely available, and if that discretion we expect to be exercised properly, right?
Yes.
But the reasons there was no fault on your part, but it was a situation which can be also envisaged from the proposed purchaser also.
Correct.
It is not that it is going to be completed within 4 months,
Correct.
but that is a possible consequence also. But yes, it was you have your actions are bona fide. It is not that you have acted in some fraudulent manner. It is not that. It is not there. So discretion lies with them to take into account all the circumstances which had resulted in delay in submission of RC and
PESO.
PESO. Right. Having noted, they are also extended perhaps, right?
Yes.
And sometimes some official acts in haste also. We have seen in other cases also. You go by that, if facts are wrong, please tell me. Okay, when I dictate.
My lord, page 137, my lord. For a moment, 137. Starts from page 136, my lord. The second extension letter, my lord.
Oh, I'll only record the facts.
Consent, my lord. Then your lordship had already noted the
I'm
same.
giving you,
Yes,
I'm giving you the discretion to
True.
consider it as representation
We'll do that.
and the facts and circumstances
We'll do
due to
that.
which
Yes, ma'am. In fact, my lord.
some kind of default.
In
Okay.
fact, my lord, what had happened in a matter which is pending today before this honorable court, my lord, in a separate matter, in fact, there's Sajjal Natta, your lordship had gone through that matter. PESO license in the name of the owner has to be done before the closing date, my lord. Your lordship is in session of the matter. So there was an amendment which was carried out by the corporation. The amendment was 16/4/2025, where that stipulation of having the PESO license in the name of the new owner was categorically stated, my lord. Categorically stated that corrigendum is not a part of this writ petition, my lord. That corrigendum, by way of that corrigendum subsequent to the ATS amendment, had come in and stated that the PESO license.
I don't remember anything of that case.
Yes, Sajjal Natta.
Mr. Once I get the file only, I can understand.
So what has happened, my lord? The LOA here, after the LOA was executed with the bidder, there was a stipulation for the bidder to have also signed the contract agreement with the corporation.
Mr. Sharma and Mr.
My
Talukdar,
lord.
we are considering this writ petition only on the law laid down
My lord.
as regards the so-called notice. Laws are settled otherwise,
My lord.
right? Then you can, if you are aggrieved, you can have many rounds hereinafter, right?
Once the final decision.
Once the final decision.
My lord.
And if it comes in your favor, then end of the matter.
End of.
My lord. I've intimated, my lord, that 10 days period has been granted by the
Tell
court.
me if that is okay.
That is okay.
And I maybe just put some sort of protection during those 10 days so that you can create third party rights.
Third party rights, they will not create.
Will-
Will ensure.
will-
I'm
By common order, it will be.
My lord. My lord.
Hard.
A similar order was already handed over, my lord.
Huh?
Yesterday, a similar order that your lordship.
Although
had-
only facts are there.
Facts are there, my lord.
Only facts are there.
My lord.
Yesterday you have placed, I think.
Yes, my lord. Bed Parivahan Limited, my lord. Yes.
As similar issues are involved and have been urged, and and similar contentions have been urged in this batch of writ petition, preferred under Article 226 of the Constitution of India, the writ petitions are taken up together for consideration. Full stop. Para. Any date of the NIT?
1/3/25. And the corrigendum is 4/4/25.
The Indian Oil Corporation Limited, IOCL, published a notice inviting tender on 1/3/2025 for inviting electronic bids within bracket e-tender under two bid system from Bonafide bidders for a contract work, quote, bulk LPG transportation contract by road for the state of Assam, Roman and Meghalaya, unquote. Full stop. The tender was floated for meeting the state-wise requirement of capacity 18 MT and 21 MT tank trucks,
Tank trucks.
TTs, of the respondent IOC Limited. Full stop. Corrigendum is at page
Corrigendum, you'll find that page 129.
what is the qualification criteria in the bid document? Mr. Sharma, it is in reference to yesterday's cases.
My lord,
There is to be a maximum age of the truck,
my lord,
right?
my lord. True, my lord. Starts at page 42, my lord.
42.
42.
And at 43, age of offered truckers.
As per the pre-qualification criteria, PQC, prescribed in the NIT stroke bidding document, bidders must offer at least one owned bulk LPG TT as on the quote unquote original closing date of tender. Full stop. And the bidder also, and the bidder should also possess a valid Petroleum Explosive Safety Organization within bracket PESO license as on the original closing date of tender for carrying LPG. Full stop. The trucks offered were required to have valid PESO licenses as on the original date of tender. Full stop. এটা নোট দিছিল আজি এটা নোট দিছিল বলবা আজি এটা নোট দিছিল কাগজ এইটো 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 এইখিনি থৈ দিয়ক Hmm. 129. Prior to the bid closing date, the respondent corporation published a corrigendum on 6/4/2025, 4/4/2025 to bring in certain changes in the terms and conditions of the NIT stroke bidding document. Full stop. Para. Where is that ATS provision?
Page 130. Serial number 5.
A new provision was introduced by the Corrigendum, allowing a bidder to offer more than one TTs if the bidder had entered into an agreement to sell within bracket ATS with owners as to bracket of tank trucks and if the bidder had entered into an ATS, then he can offer such TTs as own TTs, right? Full stop.
ATS was with an existing contractor. Contract was
As per the corrigendum, in case of TTs operating page 130, in the existing contract whose ownership cannot be transferred during the pendency of the running contract, and hence the formalities for transfer or of ownership could not be completed as on due date of the new tender, as on the due date of the tender process initiated by the NIT dated 1/3/2025. Such vehicle can be sold through an agreement to sell ATS, and both the seller and the purchaser within bracket bidder, shall have to submit an affidavit as per the prescribed format, along with the valid registration document and PESO license in the name of the seller. Full stop. Such TTs shall be considered as own tracts of the bidder for bid qualification and allocation purpose. Full stop. It has been provided that in case the bidder fails to submit the required documents with change of name, comma, etc., within 4 months of issue of letter of intent, comma, suitable penal action would be taken, comma, which would include forfeiture of EMD, comma, and caution money, and also termination of order of such TTs and blacklisting of such TTs. Full stop. In the Corrigendum, it was mentioned that under no circumstances the timeline would be extended and the respondent corporation had reserved the right and would be at liberty to induct TTs as per the methodology mentioned in the tender to fulfill the shortfall arising thereof. Full stop. The timeline allowed to the bidders to submit documentary proof within bracket STO stroke invoice of such TTs was fixed between 1/1/2025 to 15/4/2025 to confirm that they had operated stroke were then operating under existing contracts with any of the oil marketing companies, including IOCL, right?
Yes.
Full stop. Para, all these petitioners apart from owning trucks, comma, had also entered into agreements to sell with proposed buyers comma, whose own TTs were running under existing contract with oil marketing companies, including the IOCL, comma, prior to submission of their bids. These agreements are to be submitted.
Yes.
Okay. The petitioners had also submitted the ATS, then small s, with their bids. Full stop. After the bid closure date, the technical bids as well as the financial bids of the participant bidders, including the petitions, were evaluated. Full stop. Thereafter, these petitioners were issued letters of acceptance, LOAs, on 16/9/2025. Where is the LOA?
LOA minus in this case. Page 138.
The Please control. In the LOAs, the details of the TTs
One 142.
uh, for which LOAs were issued stood mentioned. These petitioners were issued the LOA in the following details. Table এখন বানাই দিব। Petition number 1, date of LOA.
Date of LOA is common.
For it is allotted actually.
But I have given a chart. Yes.
That is what I am looking at. Table, registration number. এক নম্বর কলম, 2 নম্বর কলম। Petition number to লিখিলে হবে, date of LOA. As mentioned in the following table, full stop. Subsequently, they were also issued work orders to allow them to proceed with the transportation work. তাৰপিছত টেবুলখন দি দিব 1, 2, 3 পেঞ্চিল মাৰা কেইটা দি দিব নাম্বাৰ অফ TTs allotted registration number ছটা কলম দি দিব as stipulated in the Corrigendum, the petitioners could not offer place the requisite documents regarding transfer of ownership and PESO licenses for the TTs in respect of which they had entered into ATS, a show cause notices, all dated 5/3/2026, comma, came to be issued, came to be served upon them while putting the concerned TTs under suspension with immediate effect. In the show cause notice, it was literally mentioned that the petitioners had failed to submit the required documents, that is, registration certificate, RC, and PESO licenses in the name of the purchaser of the TTs within a stipulated time period of 4 months from the date of letters of acceptance, and therefore it would call for action as stipulated specifically in the clause mentioned in the Corrigendum in the following manner. 167 একটা bolded quote করা আছে। The petitioners were asked to submit their replies to the show cause notices within a period of 7 months, within a period of 7 days. As to why further punitive action like forfeiture of EMD and caution money, including termination of contract for a concerned TTs should not be initiated against you. Full stop. It was further provided, mentioned that if the petitioners fail to respond or provide an unsatisfactory response, the respondent corporation would be left with no other option but to terminate the contract of such ATS trucks along with other actions. Full stop. Para. On receipt of the show cause notices, where is your email?
Reply is at 168. Some of the replies are on 10th March, some are on
No,
11th.
no, your association for to extend the
Yes,
time.
that my lord, at page 159.
Show cause notice was on
5/3.
5/3.
This is on 15/1.
Oh. The counsel for the petitioners has submitted that the petitioners, as the petitioners, has submitted that the petitioners had entered into ATSS wherein the proposed sellers were under existing contracts of transportation with specifically IOC.
In all cases.
With the respondent corporation itself. And the respondent corporation with its term, with the terms of those contracts ending on 30/10/2025.
3012, there were two extensions. Initially, there was an extension up to 3010, then again till 3112.
Okay. During the it was informed by a representation, the respondent corporation, PESO. However, existing contracts with tenure, with their tenure ending on August.
Initially, August it was
Ah,
ending.
with their tenure ending on August 2025. Full stop. The respondent corporation had, however, extend the term of those contracts. Firstly, up to 30/10/2025, and thereafter by another extension order, comma, up to 31/12/2025. Full stop. As due to such extension of the contracts, the petitioners extension of the contract, comma, the petitioners face difficulties to complete the formalities of transfer of ownership and obtaining a PESO license within the window period of 4 months. A representation on behalf of the petitioner was submitted by the Tank Truck Owners Association, Northeast LPG within bracket BALT before the respondent corporation on 15/1/2026. To allow to extend the time period up to 31/1/2026 to complete all the formalities as regards transfer of ownership and PESO licenses in respect of the TTs quoted offered under ATS. That is your case?
Yes.
Okay. Full stop. After in the petitioners have further submitted that in the replies to the show cause notice which were submitted within the period of 7 days from the show cause notices, All submitted 7 days?
Yes, all of them.
The difficulties faced by the petitioners due to extension of the term of the existing contracts of the proposed sellers with the respondent corporation up to 31/12/2025. And the consequence and the consequential delay arose for the petitioner to complete the formalities of transfer of ownership and obtaining PESO licenses for the TTs offered under ATS by them have been duly highlighted. In the representations, Mr. Taluga, learned counsel for the petitioners, has submitted that in the representations, the causes why the requisite conditions could not be complied with within a period of 4 months from the LOAs were mentioned, and from the reasons mentioned therein, it is evident that despite best endeavors from the end of the petitioners, the timeline stipulated in the NIT bidding document could not be completed, and for such causes which are evidently bona fide, the respondent corporation could not have issued the so-called notices indicating penal actions. As it had been indicated in the show cause notices that action would be initiated against the petitioners are before this court by these petitions with a clear apprehension that without giving due consideration to their replies, the punitive actions indicated in the so called notices would be taken. Mr. Talura has further submitted that mere failure on the part of a bidder to comply with a condition in the NIT bidding document for bona fide reason which are beyond one's control and dependent on external factors cannot be a ground for the employer to take any drastic action like so-called
167.
forfeiture of EMD stroke portion money and termination of contract, etc. etc. Para Mr. Sharma, learned counsel appearing for the respondents corporation has submitted that the petitions are premature for the reason that the competent authority in the respondent corporation is yet to give consideration to the representations and to arrive at a decision on them. Full stop. Yes, Pilot submitted that all the factors which all the events which had occurred in the interregnum, as highlighted by the petitioners in their replies to the so-called notices, would be duly taken into consideration and the decision as regards the further course of action will be taken thereafter. Hey, premature so-called notice for judgments. Will not make any comment. Hey, kita asli, kita asli lah. Kita asli gitu. Kita asli. Mr. Taludar, sorry. Taludar submission due. Mr. Taludar has submitted that of the issuance of the LOAs and the work orders, all the petitioners in the right earnest completed the formalities of transfer of ownership and obtaining a PESO licenses in their names. During the period from 19/12/2025 to 27/1/2026. Have you said so in your representation?
Yes, that's it.
Full stop. All these while, the respondent corporation did not suffer any loss as the transportation works were done by alternative arrangements.
Wait until,
Alternative arrangements after placing the TTs of the petitioners under suspension.
that is from 5.3. But that is from 5.3.
Oh, okay,
But-
okay. Did not suffer any loss.
And I continued
they-
to operate till 5.3.
Did not suffer any loss. As all this, as during the period up to 5/3/2026,
As I continued to operate.
the TTs raised by the petitioners were operated. At the instruction of the respondent corporation for the transportation work relating to LPGs. So you are under suspension from 5/3.
5.3, from the date of the show cause. That is why my contention was that the suspension is premeditated because that is attached with the suspension. Prior to that, there was no suspension. I am operating even after 15.1. 15.1 was the cutoff date. I am operating. I gave my documents. They accepted. I am operating. Suddenly the suspension comes after a month or more. And with that comes an automatic suspension, which is premeditated. That's why in that regard, I was planning to rely on Siemens and Orilex Fisheries.
Oryx Siemens General Clauses Act also will come in, but
Yes.
power suspension, that is Oryx and Siemens, it is premeditated. But
Yes.
mere suspension is otherwise. Law is also settled.
It's
If you-
permissible.
Then I have to make some observation for that. Again, you have to take recourse to another remedy instead of waiting. That is why I am not.
But what my contention was that had you issued me a show cause, because after 15.1 I continued to operate, you accepted the documents. Had you issued a show cause on 5th of
Then we have to issue notice.
My lord, they
If
continue
you go
to-
into that territory, we have to issue notice. We have to examine that.
No, because had it been a case that they did not allow me to operate after 15.1
No, my lord.
and they issued a show cause on 5.3, I would have still understood. After 15.1, I continue to operate till 5.3. 5.3 there is a show cause saying that you are now suspended.
Power to appoint, power to terminate comes with
Coexistent.
coexistence and comes with the power to suspend.
Correct.
Right?
Correct.
We go by the provisions of General Clauses Act.
Correct.
Now, it is a discretion. Sometimes a man is placed under suspension or a thing is placed under suspension so that everything can be considered neutrally. That is one aspect.
Yes.
And the other aspect, yes, pre-biased, premeditated, that is the other aspect. For that, we have to take response from the IOCL.
Correct. But my lord, may I just add one
So if
thing?
you
May-
argue on that point, then I have to
Well,
issue notice.
My lord, may I add one thing? So what happens here is that, my lord, you look at the circumstances. I would have understood on 5.3 if a show cause was there without suspension. That you respond, then probably this petition is premature because there is no lacking of jurisdiction. A show cause comes, I reply, we wait till the final order.
If you rely on Oryx and Siemens, I have to distinguish or I have to consider.
Only on the limited point.
Then I'll issue
No,
notice.
then only on this point that on 15.1 was your cutoff date. You allow me to operate, you don't issue any show cause, then you issue a show cause 1 month later or more than a month later, 1.5 months later, and you say that now you are suspended. So this suspension without my reply, without any hearing, is my lord's premeditated. So today it is a suspension. Tomorrow after 10
Then
days.
record your argument, we'll issue notice. I'll also consider your intent.
Then may I cite the
Oryx, Siemens.
My lord, the
We'll
petition,
issue notice now. We'll go for full-scale hearing.
pop it. First, my lord, see,
Having heard learned counsel for the parties, this court is of the view that the matter would require deeper examination. Issue notice returnable on 27/4/2025. Six. As Mr.
Hello. 2, 3, 4, 5, and 6, madam.
and Miss
Respondent number 1, P. Hakuria on behalf of PSO.
extra copies. No comment, this extra copies been two opinions. Yes.
para 9, Siemens. 2006 12 SCC 33. Married. Although ordinarily a writ court may not exercise its discretion jurisdiction in entertaining a writ petition questioning a show cause notice unless the same inter alia appears to have been without jurisdiction as has been held by this court in some decisions including so and so. But the question herein has to be considered from a different angle, which when a notice is issued with premeditation, a writ petition would be maintainable in such an event. Even if the court directs statutory authorities to hear the matter afresh, ordinarily such hearing would yield any fruitful result, would not yield any fruit. It is evident in the instant case that the respondent has clearly made up its mind. It explicitly said so both in the counter affidavit as also in the purported show cause notice. So a writ petition would be maintainable against the show cause notice if it is premeditated. Why I say it is premeditated in this case is as per their own final notice. They said that by 15/1/2026, you are required to submit these documents. I wrote on 15/1/2026, kindly grant me 15 days extra up to 31/1/2026. They don't reply to my representation. I still go ahead and submit those documents. As my lords noticed, by 29th, all the petitioners are submitted by 29th. All of this is accepted. Loading advices have been issued. I have been allotted LPG cylinders which I need to transport. The work was going on. So it is not a case that because of non-compliance, there was an immediate suspension. The suspension did not happen. After 15/1, I continued to operate. There was loading happening and I continued to transport. It is only on 5/3, that is more than a month after I operated business, I commenced operation. On 5/3, they issue a show cause notice which attaches a suspension with immediate effect. Now, this show cause, my lord, without any reply, without any hearing, and after the contract has commenced, was issued with suspension.
Show me any law authority that before placing one under suspension, principles of natural justice is required to be followed. Show me any judgment.
But my lord,
It can have from US Supreme Court also.
so
Show me one judgment.
they,
Please, that your proposition, you have argued. Show me any judgment that
No.
before placing one under suspension, right, one has to be heard.
may not be, my lord, but here my lords will look at the circumstances. It was not a show cause on the 16th of January. Had it been a show cause on the 16th of January saying that you failed,
Do not, everybody do not act in a hurry.
well, the contract has otherwise commenced. The contract on the 15th after the
Right,
15th,
that is why this show cause notice. And it is not the end of the thing.
that is why I am saying the show cause notice, I understand. You issue a show cause because I did not comply with the 4-month period. But the show cause attaching a suspension
Okay.
would eventually mean a punitive action, further punitive action.
Third, the learned counsel for the parties on the interim case. Mr. Talukdar has strenuously contended that after completion of the formalities, then every case is different. Then every order is different. So you have taken a different line from yesterday.
So, well,
So order belag. The Petitioner had completed the formalities of transfer of ownership and obtaining PESO licenses with utmost promptitude by January 2026. So stop. But the respondent corporation continue to utilize the PTs offered by the petitioners under ATS during the interim till 5/3/2026. So stop. Therefore, there was no occasion on the part of the respondent corporation to place the TTs under suspension at the time of issuance of the so-called notice. Full stop. The action of placing the TTs under suspension at the time of issuance of the so-called notice is clearly with a premeditated and biased mind. Full stop. In such view of the matter, the so-called notice and along with the order of suspension, petitioner has strong case for stay stroke suspension of the so-called notices, so-called notice of individual to so-called notice, and the respondent corporation shall be restrained from giving effect to the suspension of the petitioner's bank tracts and from taking any further action such as forfeiture, termination, etc. Postal. The law in support of his submissions, Mr. Talukder has referred to the decisions in Siemens Limited versus State of Maharashtra and others, 2006, 12 SSC 33, and Oryx Fisheries Private Limited versus Union of India and others, 2010, 13 SSC 427. Full stop. In para. On the other, Mr. Sharma will counsel paying for the respondent corporation has submitted that by issuance of the so-called notice, the notice has been asked simply to respond to the proposed action. The petitioner has not assailed the validity of the so-called notice on the ground of jurisdiction or otherwise. It is not a case that the legality or validity of the so-called notice has been questioned by the writ petitioner on the ground that the respondent corporation has no jurisdiction to issue so-called notice. In the absence of any challenge on such counts, the present writ petition the court should not embark on any other issue in the present writ petition. Para. In Siemens Limited Sutra, it is held that when a notice is issued with premeditation, a writ petition would be maintainable. In such an event, even if the court directs the statutory authority to hear the matter afresh, ordinarily, such hearing would not yield any fruitful purpose. To reach such view, the Honorable Court looked at the contents of the show cause notice and a counter affidavit filed and the counter affidavit of the respondent. First of Oryx, which paragraph?
27.
Para?
27. 31.
What is the thing about show cause notice? What is the content of the show cause notice?
27. Para 27.
Content?
Content. Oh, in this case. 167.
No, no, no.
No, in the judgment.
No, no, in Oryx.
Oh.
Because everything flows from the content
From
of the
the
show cause
facts of
notice and text and tenor of the language used in the show cause notice.
Yes. Para 14. And at 22 is the show cause content, the content of the show cause notice.
In Oris.
We will also see page 167 for a moment of the writ petition.
I'm reading Oris.
So just to show the similarity in the show cause here at 167,
That is why I'm trying to find out the principle.
because the language of 167.
Principle, I'm
Yes.
trying to find out the
Yes.
language in Oris. In Oris. For my show cause notice dated 23/1/2008 was issued to the appellant calling, asking him to show cause as to why its certificate of registration should not be cancelled. Full stop. The appellant replied to the show cause notice on 4/2/2008, seeking to refute the allegations leveled upon it. And stated that it would not be justified in cancelling its certificate of registration on the grounds mentioned herein. Full stop. But the respondent, without giving any reason and without giving the appellant any personal hearing, by an order dated 19/3/2008, cancel the registration certificate of the appellant. There, an appeal was preferred. By the appellant. But the bill was dismissed on 19/8/2008, holding that there was no lapse on the part of the authority who had cancelled the registration certificate of the appellant. So it was thereafter a writ petition was preferred by the appellant before the High Court. And subsequently before the whole Supreme Court. One of the questions which came for consideration was whether respondents in cancelling the registration certificate of the appellant acted fairly in compliance with the principles of natural justice, and also whether the respondents acted with an open mind. The Honorable Court has stressed for disclosure of region by a quasi-judicial authority in support of its order. Full stop. The Honorable Court has further observed that the bias of the concerned authority, which was latent in the show cause notice, became patent in the order of cancellation of the registration certificate. Full stop. The cancellation order quoted the show cause notice and was a non-speaking one and was virtually no order in the eye of law. So since the Honorable Court has further held that since the order was an appealable one, it was incumbent on the concerned authority to give adequate reasons. So it was in such background. The Honorable Supreme Court has held that a quasi-judicial authority, while acting in exercise of its statutory power, must act fairly and must act with an open mind while initiating a show cause notice. Full stop. It is settled that this court is of the considered view that an authority who has the power to appoint also has the power to terminate. Full stop. Such an authority also wields the power to suspend. Full stop. And order of suspension is not ordinarily a power or order of suspension is does not assume penal character. Full stop. But if it is prolonged suspension, and it assumes penal character. Full stop. In the case in hand, the petitioner has been placed in suspension on 5/3/2026. At the time of issuance of the show cause notice, and the petitioner has been asked to submit its reply, the show cause notice within a period of 7 days. To stop as on date, the period of suspension is about is less than 2 weeks. To stop. Para. I have perused. This court has also perused the contents of the show cause notice annexed as Annex 13 to the writ petition. First one, having gone through the same, this court is not persuaded to reach a view that the show cause notice has been issued with a closed and biased mind. In such view of the matter, the prayer for interim relief is in the form of stay of the show cause notice is and show cause notice and the proceedings thereof is declined to stop, where respondent IOCL authorities are at liberty to proceed with the show cause proceedings. before that. The law is settled that the event of show cause notice is a step towards taking a final decision in the matter by the competent authority. Full stop. A tentative view taken in the process cannot be deemed to be the final view taken in the matter. The final view will always be dependent upon the response received from the noticee, and if the noticee is able to show sufficient cause as to why no action as contemplated under the notice should not be taken, the final view may altogether be different. So stop. So the PESO does not find any justification to stay the show cause notice and the show cause proceedings initiated by the responding authorities. The respondent authorities are at liberty to proceed with the show cause proceedings for taking the same to its logical conclusion. Pendency of this petition shall not be a bar, is not a bar. The IMCL authorities to proceed further with the show cause proceedings and to take a final decision in the matter.
I'm wrong.
এই Oryx টো আৰু এইটো কি আছিল Siemens.
We have made them parties, man.
Heard Mr. Aichur, Land Senior Counsel, assisted by Mr. R. Istam, Land Counsel for the petition, and Miss Udas, Land Additional Public Prosecutor for the respondent number
26.
226. Full stop. In this writ petition, the petitioner, which is a registered cooperative society, has assailed an order dated 11/3/2026, issued by the respondent number 4, whereby the respondent number 4 has ordered that all the town panchayats by EPSS of South Salmara Mankasar district shall undertake individual lifting and distribution of their allotted PMGKAY rice from the month of April, 2026 orders or 26 onwards. Is further ordered that each GPSS, in its individual capacity, shall lift its allotted quantity of PMGKY rice from the FCI FSD as per government allocation and prescribed norms, guidelines, and statutory provisions of the public distribution system. Para. Appearing for the petitioner as referred to dated 25/11/2021. Earlier passed by the respondent of 4 earlier, whereby the petitioner society was allowed to transport the PDS grains, Tier 1, within bracket Tier 1 and Tier 2, as per government rates. Full stop. Para. When a notice inviting tender was issued by the respondent of 4 subsequently on 30/8/2024, inviting applications from interested handling transport contractors for appointment as handling and transport contractor for South Salmara district, the state NIT was put to challenge. Which writ petition?
The order is at page 31, operative portion at 35. Madam.
By the petition society in a writ petition. WBC number
5313 of 2024.
5313
24.
comma. Corrigendums. While issuing notice, comma, by an interim order dated 15/10/2024. Comma. Has observed that the NIT dated 30/4/2024 shall not be acted upon till a decision is taken by the division bench of this court in a batch of writ appeals, comma, writ appeal number 297/2018, writ appeal number 240/2018, writ appeal number 249/2018, and writ appeal number 12/2018. Full stop. Para. The Petition Society is one of the appellants in the state batch of writ appeals. Full stop. By an order dated 3/9/2018, the division bench by an interim order dated so and so. 3/9/2018. The division bench, while admitting the appeals, had observed that the appellant's hearing would continue to lift and distribute food grains from the designated, and had considered the fact that the appellant's hearing were continuing to lift and distribute food grains from the designated depots, DEPOTS, and had directed the parties to maintain status quo in respect of the existing system of distribution of PDS commodities, insofar as the transportation is concerned till a final decision is taken in the appeals. Full stop. Para Mr. Chaudhary has submitted that the writ appeals are still pending and the interim order passed on 3/9/2018 is still in currency, right?
Yes, definitely.
Okay. In such view of the matter, the impugn order dated 11/3/2026 is in violation of such interim order. He has also brought to the notice of the court that the respondent number 7-11 who are registered cooperative societies from South Salman Mankasar district. I have prepared a petition WBC number 1230/2026. Seeking a direction, seeking a direction for granting them permission to lift their respective allotted quotas without the assistance of the petition society. As I said, the petition is pending, is also pending as on date. First up. Issue notice returnable on so and so. As Ms. S.S. Roy, Central Government Council, respond number 1. As Mr. Roy and Ms. Das. Mr. Roy is for 1. Ms. Das is for 226. No formal notice, extra copies, 2 working days. Steps have been respond number 7-11 by speed post. Have been with regard to the fact that the petition society is lifting and distributing the PDS items subsequent to the order dated in lifting the allotted quotas of PDS items in South Salmara, Mankasar district. Pursuant to the order dated 5/11/2021. And considering the fact that the developments on P9/2000 has ordered the parties to maintain status quo with regard to the existing system of distribution of PDS items. System of distribution and transportation of PDS items, which order is in currency. The impugn order. Operation of the impugn order dated 11/3/2003. 11/3/2026 shall remain suspended till the returning.
Right.
2904. 29th April. Delhi list for admission, item number 1.
This will be for final disposal also.
Final disposal. I have a partner matter, Mr. Dasgupta. How much time you take? Mr. Goswami is available.
If it is available.
And Mr. Das, BD Das,
No, Vedas is not there. Sometime will be required, but in discuss.
which one?
That is no. Provocation or directive.
Not in your case,
Okay,
the other one,
For hearing matter.
hearing matter.
5-6.
Which one? 5, 6. 5 and 6.
5 and 6, yes.
Oh, who is supposed to address today?
My mistake.
Okay. How much? I don't know because of the reference.
Oh, yeah, no problem. I don't have any problem with that. You are subject to your lordship convenience. Can it be fixed the day after tomorrow or maybe?
Okay. Not day after. Today is Thursday.
It will be Tuesday.
Thursday, no. Mr. P.K. Goswami is available?
Yes, yes, I talked with him there.
His lordship, he is available today.
Which one? Yes, Mr. Sanapati.
Subject to whichever matter you
We are yet to start, my lord.
Huh?
We are yet to start.
Pattern may be taken up, we have no issue.
Well, that has gone for 2 days already. 2 days already. I don't know how much time they would take.
I'll take the minimum to place the facts, only on facts, your lordship, 20-25 minutes. Then they have to respond. So, and it's a drug and cosmetic act matter. In the end, we will have to define as to whether it's a surgical product or not.
That I don't know. I have not opened the file.
No, so it might take, say, 45 minutes for both sides.
It might.
দুটাৰ পৰা তিনটা 1 hour 20 1 hour 30 minutes are available. Okay, we can proceed then, Mr. If Dasgupta accommodates you.
Then start.
I'm not
Mr. Sanapati.
No, I am prepared. But
No,
He
I
was
subject to your
prepared.
lordship convenience. I am here.
whichever matter your lordship.
Your lordship, subject to your lordship convenience.
We can, in all probability, by 2:45, we might be able to finish it off.
Then all that, then you could proceed with that, this case.
I have already posted one also at 3. I did not know that there will be a reference. Okay, we'll proceed with Mr. Sanapati's case then. We'll fix a date for Mr. Dasgupta, Mr. B.D. Das and Mr. Goswami's case.
If I go.
It is a problem.
We'll agree on a date.
Yes.
We don't know this one. Hardly.
No, only আমার তো ঠিক হইল।
Huh?
আমার তো ঠিক হইল।
Already.
No. That should be fixed on the Tuesday. On that day, I don't know whether Goswami sir may be able to argue this case or not.
Oh. Other tender matters are posted on Tuesdays and Thursdays. Maybe it would go beyond Bihu vacation. Because last week will be motion days again. And this bench, in this bench,
Then let us try. Then
you want to start?
if it goes after vacation.
Okay then, Mr. Senapati.
Your lordship then may fix our matter after Bihu vacation only.
Okay. D. Senapati, Learned Counsel for the Petitioner, Mr. B. Goyal, and Standing Officer, Health and Family Welfare Department for the state respondents. And anybody for respondent of 5, Miss P. Agarwal and Counsel for respondent of 5 are present. Let the as agreed to by the Learned Counsel for parties release the case on
23rd of April. It's a Thursday.
Abona?
Need please, Lord. There is one matter which
Oh,
my
yes.
left hand is also appearing,
Oh, yes.
that one. So could it be given a date, Lordship, so that,
Sure. That is 2 and 3.
yes, 2 and 3.
Okay, agree on a convenient date.
Subject to his.
Lordship, any day in the first week of April, 2nd, 3rd,
Second, third.
2nd or maybe, yes, 2nd. 1st and 2nd, any date, Lordship.
Second,
April.
আগৰ ৰিপিট কৰি দিব লিষ্ট কেছ দি হয়কে আছে you are as a senior counsel
Lordship.
Interim order.
state by N Bordole
Interim
Adas Gupta
Let's.
2nd April 2 and 3 this is
Even-
ONGC
ONGC.
ONGC.
Both the cases are ONGC, Lordship.
labor
Yes, Lord. In one case, and
For item number 2 is concerned, your lordship may pass a order, because there is a mistake on my part. I could not annex the settlement.
some IA
I can be disposed of.
IA
in fact, we have annexed out that document, which my lord.
Yes, sir. He also,
We have annexed a proper readable copy.
oh এইটো কি
We filed that yesterday. That document will be in the records, Lordship.
but this IA may be disposed of. We have also filed it.
okay we'll dispose of this item third Mr. A. Dasgupta, Senior Counsel, estate by Mr.
JK Sharma.
J.K. Sharma, Learned Counsel for the applicants read petitioners. And Mr. D. Hoyka, Learned Senior Counsel, estate by Ms. N. Bordole, Learned Counsel for the opposite party, that's respondent number 1 and 2. Mr. B.K. Das,
In the second.
In the, there is no IA.
any central government council?
I am.
Okay. But here it is item number 2. Oh, post up. The instant interlocutory application
My annexer B will be replaced.
is preferred by the applicants read petitioners. Seeking amendment in the accompanying petition. Post of it is stated that in the accompanying petition, comma, a settlement dated 18/7/2012 is annexed as Annexer B. Postal. However, subsequently, it came to the notice of the applicants read petitioners that certain pages of the settlement dated 18/7/2012 were not included inadvertently. Full stop. This application is preferred. Seeking leave to amend the petition by incorporating, by substituting the settlement dated, by substituting the previous annexer B, which did not contain certain pages of the order of or of the settlement dated 18/7/2012 by the entire by the full copy of the settlement dated 18/7/2012. Full stop. Mr. Soikia,
Yes.
no objection.
No objection.
Mr. Soikia and the council appearing for the opposite party in that's respondent number 1 and 2 has submitted that the respondent opposite parties respondents have no objection to the prayer as annexer B is to be replaced by the full copy by its full copy. In the above view of the matter, the instant interlocutory application is allowed. First of the petitioner, the applicant's petitioners is permitted to replace annexer B before the registry in a period of 2 days from today. First of para in the repetition, WBC number 6576. A. Dasgupta and senior counsel, state by so and so, and D. Hoike in Likidibo. Of the order passed today in I 687/2026. The petitioner shall bring the amended writ petition on record. Full stop. As agreed to by the learned counsel for the parties, list the case on 2nd of April. 2nd of April.
Highly obliged.
Second of April.
Second.
No, second of some difficulty. Next, any other date.
In that
Then there will be motion days again.
then Lord
Whole day motion.
29th of April, Lordship, in that case.
20.
A lot of vacations are there.
BU vacations.
All the strike.
Okay.
Second of
29.
20.
Deeply.
By that time, I'll be more apprised of labor laws by Mr. Goswami. and
Even
Mr.
I was having lot of problem. I was
Yes.
also trying to go.
Yes.
And I was
Mr.
finally
Dasgupta.
I said that when he will make the submission, I will understand that.
Actually, I am learning
No,
in the other 2 cases.
It is required. Otherwise, if you are not regularly practicing,
Yes.
it is very complicated.
Very complicated. So I am confused. Basically, I am sitting here as a student. Before Mr. Goswami, P.K. Goswami and Mr. Dasgupta.
Yes, Lord. And we are privileged to hear them
Yes.
first.
Otherwise, this side of practice, lots of counsel are not having expertise.
Yes, Lord, very limited, and there are a lot of minor differences. Mediation, conciliation, all these have a
Yes,
different
yes.
connotation, meaning.
Yes. I am trying to learn.
And we think from the perspective of writ petition, it
Yes.
absolutely
No,
not.
no, it is completely different.
Completely different ballgame.
Now, after hearing you, I have been thinking how to go about it. So difficult. It is like that Bhul Bhulaiya.
Yes. One side the statutes, laws, and the other side the settlement, MOUs.
Yes, conciliation, settlement, and all this. Anyway, I'll try. Okay.
Highly obliged.
So,
Yeah, it was-
that second of 10 minutes, only 10 minutes there.
You want to start at 2?
No, I can start.
Okay, then let me dispose of the other 2 cases. At 2, we'll start afresh. Mrs. Goswami, at 2. Hey, do someone dispose? Video. Asan na.
Items 16 and 17.
Yes, Mr. Borua, can be disposed of?
Yes, on the strength of affidavit, my lord.
Ah.
Only one thing, my lord, they said in the affidavit about 20.
We'll relegate you to the authorities. They will like complete the exercise within a period of so and so. Affidavit is filed.
Affidavit is filed, my lord. They have admitted, my lord, only one portion, my lord, they said for a negotiation.
If that is done. He has said. Kali diya to. Okay. I had Mr. J.I. Borhuya, counsel for the petitioner. Mr. S.R. Borua, junior government advocate for the respondent number 1, 3,
All respondents
4,
except two, lordship.
5, 6, 7, and 8. And any BTC? There is no representation on behalf of the respondent number 2 today on call. Full stop. Para. The petitioner has stated that he is the registered owner of 2 vehicles bearing registration number tied up to the winger and so minibus. So the petitioner has stated that on various occasions, the subject vehicle was hired by the police by the respondent number.
Six. Six, no, seven, six.
Were hired on different occasions by different orders issued under the hand of the respondent number. Show me an order. MTO.
Page 16 be seen, my lord.
16.
PC Deputy Commissioner Kokrajar.
16. By issued under the hand of the by the office of the
Deputy Commissioner.
Deputy Commissioner Kokrajar within bracket. Respondent number 7. And the orders were issued under the hand of the respondent number motor transport officer.
Respondent number 8.
Respondent number 8. Full stop. The orders were passed mentioning that the vehicles were required for public services for the purpose of maintaining law and order in the state of Assam. The vehicles had been taken on hire as per the terms and conditions set forth in the order itself. So the orders mentioned that the hire charges shall be paid on submission of bills in duplicate on completion of the duty for which the vehicles were hired, and the bills would be forwarded to the concerned Superintendent of Police. For payment. The hire charges shall be paid as per the specified rates or types of vehicles. indicated therein as per a government notification bearing number so and so dated 28. As per the government notifications. As per the rates prescribed in the government notifications. Full stop. The petitioner stated that after each of the vehicles was released, he submitted bills as per the prescribed rate before the respondent authorities, as mentioned. Any table is there?
Table I did not, my lord, on a list of Rexa 2, my lord, what type of vehicles they have taken.
Lordship, page 54 of our affidavit, Lordship. Last page.
Before the respondent authorities. Full stop. According to petitioner, the total amount of all the bills had amounted to rupees 23 lakh 14,907. Full stop. As despite repeated approaches and representations, the total amount of the bills, that is rupees so and so, who was not released to the petitioner has instituted the instant petition seeking a direction to the respondent authorities to release the said amount forthwith. Full stop. In response to the writ petition, the respondent number
6, Lordship.
6 has filed an affidavit in opposition traversing the statements and averments made in the writ petition. Full stop. In the affidavit in opposition, the respondent number 2 had admitted that the subject vehicles were hired on different occasions during the period from 1/8/2016 to 24/6/2024. Full stop. The respondent number 2 had also admitted that the petitioner has submitted the bills, wherein the total amount was rupees 23,14,907. Full stop. There was a negotiation, and after negotiation, the total amount towards higher charges of the subject vehicles after negotiation, it was agreed that the total amount towards the higher charges would be revised to rupees 21,83,526. Full stop. The respondent number 2 has further mentioned that as his office is not empowered to sanction the higher charges bill to the extent of rupees 21,83,526. The matter has been taken up with the higher authorities for according necessary sanction for release of the admissible amount. Admitting that he is duty-bound to disburse the admissible amount. The respondent number 2 has further mentioned that the amount will be released after sanction and release of funds by the higher authority, subject to final verification of the admissible amount of rupees 21,83,526. Respondent number 2 has further averred that the subject vehicles which were hired from the petitioner, were used for public service and maintenance of law and order in Kokrajhar district and were released in good conditions. Post of para. When a query is put by the court to Mr. Borua, learned count, senior government advocate appearing for the state respondents, as regards the period within which the entire process of sanction, verification, sanction, and release of funds can be completed, Mr. Borua has submitted that a period of
6 months.
Yeah, 6 months too long.
verification is there.
Well, 3
Is
months
it-
is sufficient.
Where he said no verification, yesterday, same authority said no verification is required. Anyway,
They have already verified my.
For 4 months then, Lord.
3 months is. Okay.
a period of 4 months would be sufficient to complete the entire formalities. First of para. In view of the admission of liable to of higher charges to the extent of rupees 21 lakh.
Next.
83,526.
21,83,526 by the respondent number 2 and a broad consensus arrived at the parties. A broad consensus. So, 4 months of the has agreed to the period mentioned by Mr. Borua for completion of all formalities, post of time is illegal. And a broad consensus arrived at by the parties in the aforesaid manner. This court is of the considered view that instead of keeping this writ petition pending, the same can be disposed of with a direction to the respondent authorities to complete the formalities of verification, sanction, and release of funds for the amount of is 21 lakhs so and so to the petitioner within a period of 4 months from today. Post of it is accordingly ordered. Post of the petitioner shall submit a certified copy of this order at the office of the respondent number. SP is 6
SP6.
and DGP
LGP 4, Lordship.
and the respondent number 4, so as to enable the said respondents to complete the entire process to facilitate expeditious disbursement of the admitted amount to the petitioner within the period mentioned.
Lordship,
This
can
order
it be,
disposes of the repetition.
can it be 4 months after receipt of the certified copy? That will
It
be
will be
better.
too late, my lord. I have already hired from bank, my lord. They have done already, my lord. Verification.
Okay, 4 months from the date of receipt of a certified copy of this order. Of 4 months. It is accordingly ordered that the entire formalities shall be completed within a period of 4 months from the date of receipt of date of submission of a certified copy of this order. It is accordingly ordered.
My lord, one thing, my lord, lordship has dictated respond number 6 or 2 admitted, my lord. It will be respond number 6.
6.
Affidavit to respond number 6.
All right.
Next one is
Lord,
also same, Lordship.
Next is also same, but districts of
District is also same.
district also same.
District also same.
Same. Only amount is
This
57 0
Respondents are also same.
same.
Respondents are also same.
Also same.
Everything is same.
খালি affidavit opposition লিখিব।
They are also respond number 6 file affidavit.
Respond number 6.
Whole amount.
ইয়াতে vehicle হ'ব
Next up,
paragraph 2. 5, huh? 5খন আছে। Subject vehicles কৰি দিব। বাকিখিনি একেই। Total bill amount
57.
57 04974.
57 lakh 4,974. In the affidavit in opposition, Commander Respondent number 6 has admitted about hiring of the subject vehicles from the petitioner during the period from 2020 to 2023 for maintaining law and order situation in Kokrajhar district. The petitioner, Respondent number 6 has also admitted about receipt of bills from the petitioner for towards higher charges. Full stop. The respondent was, it is averred that admitting that he is determined to disburse the higher charges. Comma respondent number 6 has averred that the same can be released after sanction and release of funds by the higher authority subject to final verification of the admissible amount of rupees 57 lakh 4,974. By Hinike. Okay.
Then disposal.
Item number 2, Your Lordship has passed the order a while ago. Item number 2, Your Lordship, in the IA. Yesterday, Your Lordship, we have filed a affidavit in the IA whereby the original MOS dated 18/7/2012 has been annexed by the ONGC, Your Lordship. The applicant, they had only annexed the type copies in the IA annexure that your Lordship has ordered for replacement. That has not been in the record, Your Lordship, because yesterday I filed it, Your Lordship,
Okay.
in the IA.
That will come in the IA.
IA got disposed of today, Your Lordship,
Okay.
but it's not in the record, our affidavit. The original document was annexed for the assistance of the court, Your Lordship.
Yes. In your counter file in the repetition, that document is available.
No, Your Lordship. That is the issue. If
Now
annexment
they have brought type copy.
Yes, Your Lordship. Lordship, if
to type copy করে দিব। The the affidavit submitted by the opposite party, that's respond number 1 and 2. It is submitted that it is submitted on behalf of the opposite party, that's respond number 1 and 2, that an affidavit on their behalf has also been filed in order to bring the settlement dated so and so on record.
yesterday.
Yesterday. It is submitted that it is further submitted that the annexer that annexer B, which is sought to be replaced by is sought to be replaced by the applicants, the petitions, is a type copy.
That Your Lordship may not write because, but then if Lordship peruses the IA, the original is not there, Your Lordship. The annexure original pages are not there, Your Lordship.
A line to nalage, second line to nalage. Office to trace out the affidavit of the affidavit stated to have been filed by the opposite party, that's respond number 1 and 2, comma, to place the same in the case record. Also again disposal. If you want to bring a more authentic copy, Bring in the writ petition. If you have the original copy, legible copy.
Yes, legible copy.
Bring in the account by way of an additional affidavit in the writ petition.
Petition.
That will be better.
Because
Because
it already got disposed of.
this is
Today.
disposed of.
Yes, Your Lordship.
So you bring in by way of a short affidavit.
Lordship may kindly
dictate
that in the order. I'll do it.
In the writ petition order. The response number 1 and 2. To bring a legible copy
Of the MOS dated
settlement dated
18/7/2012.
by way of affidavit. The leave is done. Like in order academy.
Your obliged, Your Lordship.
Because it will be in the IA.
Yes, Your Lordship.
It will be very difficult to refer to that.
Yes, Your
So
Lordship.
bring it on record by way of an
I'll do it.
additional affidavit.
Deeply obliged.
Item 14 supplementary.
14. It will also take some time, my lord.
Yes.
May be taken up after the Bihu vacation, Lordship.
But both sides will agree the 30th of April, my lord.
30.
Interim to
Zero.
continue.
B. Chaudhary, petitioner, Zian Sahalan, as senior counsel, assisted by Mr. and Anik Singh, counsel for the response number 3451 are present. Also transfer for an agreed to be and counsel for the parties. This is the case on 34/2026, the interim order. The fast track will continue till the next date of listing.
Well, I have an unusual request, my lord. One blacklisting matter was, my lord, fixed on various dates, but your lordship could not.
No, I have reserved.
My lord, they have some tender on 25th, my lord, 2 tenders. So.
Well, I'll try. Because of some emergent situation in my
My lord.
own house.
Because no interim order was there in that matter. That is why, my lord.
Because of emergent situation in my own house, I could not
Okay,
complete it.
much of my lord. Anyway, my lord, only just, only the request, my lord.
Some situations.
Yes.
Daily list for hearing, items 5 and 6.
Below level. খুলি দিয়ক খুলি দিয়ক
Oh.
Refers some judgment, lord. Thereafter, on the final day, relevant facts. First, lord, what I would like to submit, that this Contract Labor Regulation and Evolution Act 1970 is a special act. For that so, and it was the observation made by the Bombay High Court, the Rajasthan High Court, that is 1993 to LLJ 1014, copy to Didier.
93 1 LLJ.
2 LLJ. 2 LLJ, paragraph H. Page 1014. Paragraph 8, my lord. May I read that?
Yes.
The ID Act was enacted in the year 1947 and deals with all aspects of industrial disputes. Applies to all industries and the workmen coming within its fold. Previously, the dispute relating to the contract labor could be referred for adjudication under the provisions of ID Act. As Rajasthan Amendment Act included in the definition of the workman any person who is employed in any industry by an employer or by a contractor in relation to the execution of this contract with such employer to do the various kinds of work mentioned in section 2S of the ID Act. Therefore, ID Act is admittedly a general enactment. Out of generality of the matters falling within the purview of ID Act 1970 purview of ID Act 1970 takes out one cases of contract labor and legislates exclusively thereon. Evidently, therefore, Act of 1970, that is contract labor, is a special enactment which has been legislated to apply only to the subject of contract labor, whether they are employed by a contractor or they work in an establishment. The Act is therefore a special central enactment and will prevail to the extent that it applies over the provisions of ID Act 1947, which is the earlier general law pertaining to the subject of contract labor, and the power to refer a dispute to adjudication connecting the same. Since the special central legislation prevails over the earlier general law as was provided under ID Act, the government therefore prevails over the earlier general law as provided under ID Act. The government therefore cannot make any reference of dispute on the subject of contract labor under the provisions of the ID Act. This much will be, so far the subsequent things are concerned, that is defined with respect to this case only. Now, Lord, to fortify this, your Lordship may have a glance on section 30. In the last occasion, I have pointed out it, of course. As it is a special act, Millard. The provisions of this act shall have effect, notwithstanding anything inconsistent therewith contained in any other law. That is very much important. Any other law or in the terms of any agreement or contract of service or anything standing orders applicable to the establishment, whether made before or after the commencement of this act. This indicates this is a special law. The second proviso indicates that it is a special beneficial law. Provided that proviso indicates that it is a special beneficial law. Provided that where under such agreement, contract of service or standing orders, the contract labor employed in the establishment are entitled to benefits in respect of any matter which is more favorable to them than those to which they would be entitled under this act, the contract laborer shall continue to be entitled the more favorable benefits in respect of that matter, notwithstanding, that is important, that they receive benefits in respect of the other matters under this act. So if therefore anything is more beneficial, then that will be applicable, Milan. Now, so far, this proviso is further fortified by subclause 2. Proviso to section 31(1). Nothing contained in this act shall be construed as precluding any such contract laborer from entering into an agreement with the principal employer or the contractor, as the case may be, for granting them rights or privilege in respect of any matter which are more favorable to them than those which they would be entitled under this act. So basically, this is a special act, and secondly, this is a special beneficial act. Now, it can be, your Lordship can look into section 31. Power to exempt special cases. The appropriate government may, in case of an emergency, direct by notification in the official gazette that, subject to such conditions and restrictions, if any, and for such period or periods as may be specified in the notification, all or any of the provisions of this act or the rules made thereunder shall not apply to any establishment or cases of establishment or any class of contractors. But this provision was applied in the Food Corporation of India, where some establishments where probably we should tell to where there are some establishments, some godowns where this contract labor act will not be applicable. That is in pursuant to a judgment rendered by the Bombay High Court, if required in the next. Now, my lord, I shall refer some other cases. First case that is I would like to refer, my lord. Gujarat Electricity Board दीजिए, T5 folder to दीजिए. गुजरात Electricity Board को सुन दिया. और बताए तुम दीजिए. Here the entire scheme of this act was briefly analyzed. Now, paragraph 12, 13, 14, 15, 16, 18. Your Lordship straightway come to page 1995 5 SSC page 27. 1995 5 SSC page 27. Relevant paragraph to लिखना है ना. Page 41. Itu asal kata tu लिखा ना होना, dia गंडगोल हो, टाइम लगेगा. ये तो ये लिखी ही ना हो. Section. But paragraph 17. It starts from paragraph 12, 13, 14. So for the timing, we can skip it off because relevant provisions have been discussed. Here, for the timing, we can skip it off, but these are relevant. Paragraph 12, 13, 14, 15, 16, 18. Now, straightway, we can come to paragraph 17. At the bottom portion, just 1, 2, 3, 4, 5, 6. Last but 6 lines, below. Paragraph 17, page 41.
Yes.
But section 30, they refer.
Yes.
Section 30, make laws and agreements inconsistent with the Act inactive while saving more beneficial service conditions of the contract laborers. Now, Section 31 empowers the appropriate government to grant exemption to any establishment or class of establishment or any class of contractors from complying with the provisions of this Act or the rules made thereunder on such conditions and restrictions as may be prescribed.
Section 31 is not made applicable.
The section 31 is that if the Contract Labor Regulation and Abolition Act is applicable in an establishment, appropriate government for certain reason may invoke section 31 so that this act will not be applicable.
But nothing as a notification is there. No,
No, in this case it is not necessary. Just to fortify that this is a special act. When section 31 is invoked, then the provisions of Contract Labor Regulation Abolition Act will not be applied. Now, so at this time I am not reading this 12, 13, 14, 15, and 16. Now, Your Lordship, come to an act, Bhel Workers Association, Haridwar versus Union of India and others, 1985, 1 SCC, page 630. It is in Paba. Page 1985, 1 SCC, page 630. Para 6. Page 9. Relevant page is 636. Yeah, page 1. Here in the spiral bending, Lordship will file at page 98. The spiral bending, it starts from 98,
Yes.
and relevant page will get at 104 page. And in the judgment below is 636 page.
Yes.
Now, Millard, let us start. All these things they are dealt. So for paragraph 5 is concerned, scheme of this act has been spelled out. Entire section. So I am not reading all this thing. Only section 5, etc., 7, 8, 9, 10, 11, 12, all these things. Here also section 30. No, 30 has not been dealt with. Section 35. Now, so here the basic question is that this line is very much important. equal wage for equal work. So whether there is any distinction or not, for the purpose of giving equal wages to a contract labor for performing same or similar nature of job, whether there shall be any distinction or not. So after discussing all the provisions, starting from page, it will take some time. So for the timing, I am skipping it up. Or should I read it?
Which one, which paragraph you are reading?
I would like to refer paragraph 6.
Okay.
In order to fortify the paragraph 6, Lord, the Lordship has discussed in paragraph 5, where the entire scheme of the Act has been.
Okay.
So should I read it?
No, paragraph 6 you can read. Paragraph 6.
Now, your Lordship may start it at page. Before starting paragraph 6, your Lordship, page number 104.
Yes.
Second line. Let us start it from second line.
Yes.
Rule 25 prescribes, so far the Rule 25 is concerned, Rule 25 is for implementation of Section 12. Section 12 of the Act. Rule 25 prescribes the forms, terms, and conditions of license. Rule 25(2)(5)(4) prescribes that it shall be the condition of every license that the rates of wages shall not be less than the rates prescribed under the Minimum Wages Act 1948 for such employment where applicable, and where the rates have been fixed by agreement, settlement or award, not less than the rates so fixed. Rule 25(2)(5)(a) prescribes that it shall be the condition of every license. It shall be the condition of every license, that is important, in case where the workman employed by the contractor perform the same or similar kind of work as the workman directly employed by the principal employer of the establishment, the wage rates, holidays, hours of work, and other conditions of service of the workman of the contractor shall be the same as applicable to the workman directly employed by the principal employer of the establishment on the same or similar kind of work, provided that in case of any disagreement with regard to the type of work, the same shall be decided by the Chief Labour Commissioner Central, whose decision shall be final. Similarly, Rule 25(2)(5)(b) provides that in other cases, wage rates, holidays, hours of work, and conditions of service of the workman of the contractor shall be such as may be specified in this behalf by the Chief Labour Commissioner (Central) while determining the wage rates, holidays, hours of work, and other condition of service under Rule 25(2)(5)(b). The Chief Labour Commissioner is required to have regard to the wage rates, holidays, hours of work, and other condition of service obtaining in similar employments. There is no dispute before us that the Payment of Wages Act applies in as much as to contract labor as to labor directly employed by the principal employer of the establishment. After discussing the entire scheme of this Act, the court came to a conclusion. It is very much important for our case. Thus, we see that no invidious distinction can be made against a contract labor. Contract labor is entitled to same wages, holidays, hours of work, and condition of service as are applicable to the workers directly employed by the principal employer of the establishment or the same or similar for the same and on the same and similar kind of work. They are entitled to recover their wages and their condition of service in the same manner as worker employed by the principal employer under the appropriate industrial or labor laws. Here the Industrial Disputes Act will be applicable. Labor laws. If there is any dispute with regard to the type of work, the dispute has to be decided by the Chief Labor Commissioner Central. It is clear that the Parliament has not abolished the contract labor. It is not very important for our case. Till then I am reading. It is clear that the Parliament has not abolished contract labor as such, but has provided its abolition by the central government in appropriate cases, Section 10 of the Contract Labor Regulation Abolition Act. It is not for the court to inquire into the question and to decide whether the employment of contract labor in process, operation, or other works in an establishment should be abolished or not. This is a matter for the decision of the government, and after considering the matters required to be considered under Section 10 of the Act. Similarly, the question whether the work done by the contract labor is the same. Similarly, the question whether the work done by the contract labor is the same or similar work that done by the workman directly employed by the principal employer or of any establishment is a matter to be decided by the Chief Labor Commissioner under the proviso to Rule 25(2)(5)(a). In these circumstances, we have no option but to dismiss the writ petition. This is the one thing. Another Supreme Court judgment, my lord, I would like to refer. যেমনটো পিছত দিম এইটো দিব তাৰ আগতে সেইটো হৈ দিব গুজৰাট ইলেক্ট্ৰিচিটি দেখুৱালে নহয় এইটো কৰা আচ্ছা দিননাথ দিয়া ঠিক আছে হেৰি কৰা দিননাথটো দিয়া আমার ইয়াত দরকার নাই দিননাথটো ইয়াত হেৰিত আছে ন ইয়াত নাই নেকি দি দিয়া ওটা দিলা নেকি another decision that I would like to refer, my lord, that is Dinonath versus National Fertilizers Limited. That is 1992, 1 SCC, page 695, para 10. Relevant page is 699. Section 30, 699, no, Jana? What does it? Section 30 provides the laws and it. Para 10. Wait. That is with regard to section 30. Section, last but 3 lines, my lord. Here, defined sections have been discussed. While discussing this section, this court has an occasion to make some observation on section 16. Section 30. Last but 3 lines. Section 30 provides that laws and agreement inconsistent with the provisions of the Act shall be void. Shall be void except where such agreements or contracts or standing orders afforded more favorable facilities to the employees than provided under the Act. Under the Act, we shall also refer, that is page 700, refer to Rule 25 of the rules, which mentions condition subject to which license could be issued to a contractor under section 12. The said rule inter alia provides that the license issued to a contractor shall not be transferable. The contractors cannot employ workmen in excess of the number specified therein, and the rates of wages payable to the workmen shall be the rate prescribed under the Minimum Wages Act 1948. Clause 5A of the Rule 25(2) is important and read as follows. Look, in cases where workmen employed by the contractor perform same or similar kind of work as the workmen directly employed by the principal employer of the establishment, the wage rates, holidays, hours of work, and other condition of service of the workmen of the contractor shall be the same as applicable to the workmen directly employed by the principal employer of the establishment on the same and similar work. Rule 25 further provides for accommodation. That is not very important. Now, let's another judgment of Supreme Court. Thus, mode of recruitment, etc., were dealt with. According to their case, is that the mode of recruitment of the contract labor is defined from the mode of recruitment of the principal employer. Where this has any bearing on Rule 25 to 5A. The Supreme Court has dealt with this case, Miller. That is a case of 2018, volume 16. Page 25. SCC, sorry. 2018, volume 16, SCC, page 25. You put folder to the
It's well from
my folder to the relevant page is para 5. So here the page number to question. Page number to one, sir. Spiral binding, it is page 54, Milord. In spiral binding, it is
Yes.
page 54 to 56. আপনার সাইল করতেছে কালি রাতি ফোল্ডার করছে ইয়া দেখি প্যারাপার 5, 6, 7 তিনটাই করি Let us start from paragraph 5. This question cropped up in this case, Milord. The distinction made and the finding recorded by the High Court on the basis of the source of recruitment also is not correct. There has to be difference between the source of recruitment. Even then, Rule 25 of the rules confers protection. It is a special act. As permanent employees have to be inducted by the employer by a different set of procedure, whereas for workers employed by the contractor, the procedure of induction is bound to be different. Prima facie protection is conferred of similar wages to the employees engaged by the contractor. The impact of specific Rule 25 of the aforesaid rules and the law in this regard has to be taken into consideration before coming to a conclusion. Paragraph 6. The qualification aspect vis-a-vis to provision, if any, in recruitment rules has also not been discussed by the High Court in its judgment. There is no consideration of the qualification prescribed for the two different sets of employees. Merely few employees possessing ITI certificate would not make a difference. The High Court should have given the finding in concluding paragraph with respect to the qualification being different without considering the qualification. It's in Constitution to answer again. The High Court should not have given a finding in concluding paragraph with respect to the qualification being different without considering the qualification prescribed for two sets of different employees. The observation that usually workers employed by the contractor do not possess the qualification is based on assumption which was not warranted. Similarly, with respect to slight variations in the nature of work on the basis of whose cooks are cooks which item, the High Court could have brushed aside the similarity. Often the preparation of, this is not very important so far our case is concerned, often the preparation of snacks is different than the preparation of the regular food. There has to be a substantial difference between the nature of work. That cannot be the basis of items to be cooked in the face of the case. In case somebody is preparing regular food, somebody is preparing the snacks, that cannot be substantial ground so for the to differentiate the nature of the work, etc. etc. এটা হলো না আচ্ছা তুমি নেক্সট কেসটু হেরি টু আনা এই মাদ্রাস হাইকোর্টের যেটি জাজমেন্ট Now, my lord, the petitioner has referred a large number of judgments on equal pay for equal work. And their contention is that the equal pay for equal work is not always applicable if the status is not same, nature of work is not same, or the responsibility is not given. All these things will be. Basically, what I have understood, I have not yet find any supporting judgment of my own conclusion. I'm trying to subject to rectification to your lordship. Now, what I have believed that is Article 39 of the Constitution of India prescribes the equal. Subject to rectification, I'm not very much sure of it. अपने अलग Constitution together. Directive principles.
Yes.
Article 39, certain principles of policy to be followed by the state. The state shall in particular direct the policy towards, let us skip it up, A, B, and C. Let's directly come to clause D. That there is equal pay for equal work for both men and women. This is the directive principles, my lord. Now, my lord, now let us come to Article 37. The provisions contained in this part shall not be enforceable by any court. But the principles therein laid down are nevertheless fundamental in the governance of the country, and it shall be the duty of the state to apply these policies, these principles in making laws. Now, my lord, based on this Article 39 clause D, probably first case was it is on the 1982. All these cases into judgment to the Bundu Basil, Pavilion, Madras High Court judgment. Page 24. It is, my lord, I would like to refer one High Court, that is a Madras High Court judgment, my lord. Though in this case, this aspect has not been dealt with, but my idea to some extent has been conveyed. I have not stated, but the one episode come there, more called. এইগুলো এই 2018 কব লাগিছিলে পিছত কম দিয়া তুমি এই মাদ্ৰাছ হাইকোৰ্টটো পেজ 24 না স্পাইৰাল বাইণ্ডিং মিলাৰ পেজ 24 মিলাৰ Even page to go to 8, 9, 11, 12, na? Here this point was raised, Lord. 8, 9, 10, 11, again. Page 31, no? The relevant page is, so far as spiral bending is concerned, it is page 31. Here, পাৰ্টি আৰু বেলেগ এটা পিছলৈ কথাটো কৈ দিয়াটো ভাল চাইটেশ্যনটো নাই alternate anyway but yeah let us start from paragraph 8. The pronouncement made in official, there is a Supreme Court judgment, official liquidated versus such and such in paragraph 38 is that these are all the Supreme Court cases. Paragraph 95. The ratio of Randir Singh versus Union of India, etc., and several cases. The court consciously and repeatedly deviated from the ruling of Randir Singh, first judgment. Randir Singh versus Union of India, Supra, and held that similarity in designation or quantum of work are not determinative of equality in the matter of pay scales, and that before entertaining the accepting claim based on the principle of equal pay for equal work, the court must consider the factors like the source. These are defined below. Source and mode of recruitment, appointment, qualification, and the nature of work, the value of judgment, responsibility, reliability, experience, and confidentiality, and financial need, etc. Now, my lord, what we see, my lord, so far the contract labor regulation evolution is concerned, it is totally different. As appeared from this 2018, volume 16, 25. Because of the fact, my lord, there is a specific rule 25. Probably it is my idea, my lord. But the Supreme Court has specifically stated so, that this rule will protect. The said judgment of the Honorable Apex Court do not deal with the similar situation in hand. Here the 25 will come, in which the employees concerned have approached the authorities under Contract Labor Regulation and Evaluation, Central Rules 1971. The issue in those cases, fixation of pay between the equal and permanent employee. The issue has been raised directly either before the Central Administrative Tribunal or before the High Court, which ultimately needed before the Honorable Supreme Court. This court is of the view that the said judgment relied upon the learned counsel for the petitioner do not have any application to the case in hand because of this rule. In order to appreciate the issue before this court, it is relevant to extract Rule 25(5)(a). So far, directive principle is concerned, there is no such rule, enforceable rules. Of the Contract Labor Regulation and Evaluation Central Rules 1971, the same is extracted here under. We have repeatedly read it, so let us keep out 25(5)(a). Now, paragraph 11. The provision contained in Rule 25(5) of the Contract Labor Regulation and Evaluation Central Rules 1971 makes it very clear that in a case where the workman concerned is employed by a contractor perform the same or similar kind of work directly employed by the principal employer, then the benefits to such person shall be the same as applicable to the workman directly employed by the principal employer. Therefore, the said rule mandates that the benefits should be equal to a workman engaged by the contractor as against the workman engaged by the principal employer. Hence, considering the said provision coupled with the factual findings given by the first respondent, the court is of the view that the contention of the learned counsel of the petitioner cannot be accepted. Now, my lord, they have, while coming to this conclusion, they have relied upon this Vale judgment, which I have already referred, 1985 1 SCC page 635, no? 630. Cannot be said. Workers Association Hardar, Vale Workers Association Hardar, Union of India and others, 1985 1 SCC page 630, considering the very same rules. Supreme Court, it has been held by the Honorable Apex Court in the following manner. Section paragraph 5. Section 5 provides the licensing of contractor. Section 13, 14, and 15 provides for the grant of license, revocation, suspension, and amendment of licenses and appeal. Section 16 to 21 makes detailed provision for the welfare and health of contract labor. Section 20 in particular provides that any amenity requires to be provided for the benefit of the contract labor employed in an establishment is not provided by the contractor within the prescribed time. Such amenity shall be provided by the principal employer. Section 21 makes the contractor responsible for payment of wages to each worker employed by him, contract labor, but further prescribes that the principal employer shall nominate representative duly authorized by him to be present at the time of disbursement of wages by the contractor. Section 22 to 27 provides penalties and procedure. Section 28 provided for the appointment inspecting service. Section 30 makes the provision of the Act effective, notwithstanding anything inconsistent therewith contained in any other law or in terms of any agreement or contract, service, or standing orders applicable to the establishment. It, however, saves the contract labor any favorable benefits that the contract labor may be entitled to under the agreement, contract, service, or standing order. Section 35 invests the appropriate government with the power to make rules for carrying out the purpose of this Act. Rules made by the central government are required to be laid before the House of Parliament for total period of, this is important, rule making procedure. Rule 25 prescribes the form, etc. license. Rule 25 to 5
to consider representation within 6 weeks with personal hearing.
Rule 25 to 4 prescribe that it shall be the condition of every license that the rates of wages shall not be less than the rates prescribed under the minimum wages for such employment where the applicable, where the rates have been fixed by agreement, settlement, award, not less than the so fixed. In case, now this is very specific, in case where the workman employed by a contractor perform the same or similar work as the workman directly employed by the principal employer, the establishment, the wage rates, holidays, hours of work, and other conditions of service of the workman of the contractor shall be the same as applicable to the workman directly employed by the principal employer of the establishment, provided that this. Similarly, let us keep it up. Now, thus conclusion. Thus, we see that no individuous, yeah, I have pointed out other attention. Now, take goal, na? It's going to get the khaba. What time is it, right? Airport authority goal, na? Chemical. First time contract লঘু উদ্যোগ versus VG Mohiti. It was a need to declare page 43. Here there is another distinction, that is equal work, not equal, similar work is essential. Same and similar. So, in this regard, I would like to refer one judgment, contract Loghu Udyog versus GG Mohiti, 2001 to LLJ 1398. 2001 to LLJ.
2001 Supreme Bombay.
It is not power. It is popular journal. It is jane. 2001 to LLJ 1398. Legal bad. You'll find it at our spiral binding, human page 43. Paragraph number 1. 7, 8, 9. Paragraph 16. Paragraph 16 and 17. No? One down. One down for time over there. Statewide lordship farm. Human both time lagibo. দেখো যে আমি আর দিন তো টাইম পামি এটুকু জাস্ট এটি দেখা দিও প্যারাগ্রাফ 15 মিলার our file binding page is 50.
Yes.
Paragraph আপনার 15. Once file binding out. কি বলে? 15. Okay, just বাকি বিলাক নপাও এটো টাইম নহব। এই ইন্টারনাল পেজ হচ্ছে 50. Response number 1 has proceeded on the basis of the report of the government labor officer, which indicates the work done by the contract labor was not the same as done by the contract workers. Of the response number 2. Paragraph 15. Response number 2. And unconnected with the manufacturing activities. This approach is wholly inappropriate, would defeat the legislative intent. We are of the opinion the expression perform the same kind of work occurring Rule 25 have to be understood in the context of the definition of the workman. Section 2(1) of the Act 1970. It is well settled that the statutory rules must be interpreted in such a way that it does not whittle down the act of the Parliament in any respect, for the rule would become ultra vires. The rules are framed in aid of the Act. Understood thus, the nature of work done by the contract labor will have to be classified as skilled, semi-skilled, unskilled, manual, supervisory, technical or clerical work in the establishment, and not physically comparing with the actual work done by the regular workers of the establishment relating to manufacturing activities alone or otherwise. The definition, Lordship, now it is 310. এটা বলে দিব
315 we are rising. 315 no?
তিনটা নয় তিনটা 15 ঠিক আছে
315.
Physically comparing with the actual work done by the regular workers of the establishment relating to manufacturing activities alone or otherwise. The definition workman in clause 1 of subsection 1 of section 2 of the Act means the person employed in connection with the work of any establishment do any skill, semi-skill or manual, supervisory, technical or clerical works for hire or year, whether the terms of employment be express or implied, but does not include any such person. This may keep up, that is the administrative capacity, etc., etc. Now, paragraph 16. Paragraph 16, same and similar work, that is line 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 11 and 12. 12 lines, starts from 12 line. Paragraph 16. Undoubtedly, the Apex Court has expressly left the question recording the words same and similar occurring in Rule 25 open without expressing any opinion. In our view, it is not possible to entertain the submission advance on behalf of the respondent that the provision would apply only when contract labor demonstrate that he was doing exercisingly the same kind amount of work as the regular workman of the page 51. Same kind of work as the regular workman of the establishment. On the other hand, we are of the view that it would be enough for the contract labor to demonstrate that work discharged by them was in connection with the work of the establishment to do any skilled, semi-skilled or unskilled, manual, supervisory, technical or clerical work for hire or reward. On conjoint reading of the definition of the workman with clause B of Rule C or clause B and C of Rule 25(4) of the Maharashtra Contract Labor, the submission made on behalf of the petitioner union that the duty cast upon the authorities under the Contract Labor Regulation and Regulation Act to ensure that the waste specified in this behalf by the Commissioner of the Labor Commission, this is the act. Labor observed. Necessarily, we will will have to make reference to the schedule specified by the government in the notification issued by the exercise of the power compared minimum wages act. Even under the, this is not very relevant, my lord. Yeah.
I think
2 or 3 judgment I will refer him.
it will be possible.
No, not possible.
March.
As a fixed matter in Adityanawar. 31st. And another case is fixed. Huh?
Petrol.
35% yeah, that's a fixed way, sir. Provision fund, এই কোর্টে নয়, ব্যালেট কোর্টে, এই কারণে প্রবলেম আছে। কমিটি সিকিউর কোর্টের ফিক্সড আছে। 31st March.
Second bill is already given a review.
I have a fixed matter in the 31st March. Board of Justice
Maybe in the second half, we can accommodate on that day. If you are in station Gauhati, you are in Gauhati.
30th I will be Itanagar.
31st,
30th I will be Itanagar.
31st will be here.
After you should, your lordship, if I may say so.
All right.
Your lordship may have 2 days of the week so that
Yes.
it is finished.
Better
So that
to
it-
have case this case at least on 2 days in a week. Tuesday, Thursday, it can be completed.
Correct. That is, then it will remain fresh.
Today even I forgot it. Many things.
No, not everyone forgets.
Everyone forgets.
Not that.
We have only one case before your lordship, but your lordship has 30 cases.
30 cases, 40
That is the
cases.
problem.
I sometimes.
April suffered. You don't clean. Okay. Courtmaster says that he will keep the slate clean on 5th of May and 7th of May.
As your lordship.
As well.
Otherwise,
It is subject to your lordship's
Yes,
opinion.
that will be a first class.
7th of the
No.
Okay. I go to you, Mr. P.K. Gussamil as senior counsel, I stayed by Mr. With Mr. K. Kolita, learned counsel for the respondent number. Respondent oil is and Miss Egaya, the environment counsel. For the respondent, Indian India present. Mr. A. Rajgopal and senior counsel is by Mr. D. Chuti. And counsel for the respondent number 3 in WBC number 8150/2017 has completed his submission in part. So, as the submissions are not complete, list the cases again on 5th, 5/5/2025 for further consideration. The interim order continue.
এবার sleep আছে।
Mr. Das, I did not know there will be difference. So any day in the next week, I am fixing it. Same thing. Any day in the next week, whatever is possible, right? Mr. Sharma? I did not know that there will be difference.